You're tuned in to Agriculture Today, and we start our Wednesday show this week with an agricultural law update. And for that update, we're joined with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us once again.
Good to be with you, Shelby.
Roger, getting started talking about a recent article you've written, the EPA finalizes amendments to WOTUS rule. And so can you give us some background about that?
Right, Shelby. We talked about this whole issue a couple of times in the past. This has been one of the biggest issues in agriculture this year, particularly because we've had the U.S. Supreme Court decide a case on what the definition of a wetland is for purposes of the Clean Water Act and jurisdiction by the Corps of Engineers and the EPA. And prior to the opinion being released on May 25, the agencies had actually put out a new rule overturning the Trump administration rule and focusing on the significant nexus test. Well, when the Supreme Court opinion came down in late May, it basically largely obliterated the agency's new rule, which went into effect in March, and said, no, the significant nexus test is the wrong test for determining whether a wet spot in a farm field, for example, or a ditch or a stream that sometimes has water in it but sometimes does not, is subject to federal jurisdiction. That's the wrong test. The test is the continuous surface water connection test. And the court was unanimous in rejecting the significant nexus test. And Shelby, it's very rare in a major environmental case that we see the Supreme Court being unanimous on anything. But they were on this, and they said, no, the significant nexus test is the wrong test. All 9 justices said that, and all 9 said that the Sackett's tract was not a wetland. And so the agencies, after that opinion, I think probably reluctantly so, but had to go back and amend their rule and eliminate the significant nexus test and insert the continuous surface water connection test as the proper jurisdictional test.
So almost a little bit of like a power struggle there between people not doing it correctly?
Well, whenever there's a power struggle between the agency and the Supreme Court, we know who wins that one. The Supreme Court will win that one.
Talking about the Sackett opinion and kind of what we've seen there.
Well, the Sackett's had a tract of land in northern Idaho that was about 100 yards from Priest Lake. Now, Priest Lake is a jurisdictional water of the United States, but there was no continuous surface water connection from their tract across other tracts to the lake. And the government came in and said, well, there's a significant nexus. It's connected to this, it's connected to that flows into Priest Lake. And that's how they claim jurisdiction. And that's what the court said was wrong. That is the incorrect way to determine whether a wet area is a jurisdictional wetland. And that's why this is important for agriculture, because the agencies will not be able to connect the dots with a small wet area in a farm field or a ditch or a stream that often, say in western Kansas, does not have water in it. They can't use that to connect to something else that ultimately flows, for example, into the Missouri River, which is a water of the United States. So the Sackett opinion is very favorable for agriculture, but I would remind people that even though we have these EPA amendments and the EPA and the Corps appear to be conforming their rule to what the U.S. Supreme Court has said, that there are still other ways that farmers can get in trouble with the federal government when it comes to wetlands. And one of those is under the Swamp Buster rules. And the Swamp Buster completely has a different definition of a wetland for government jurisdictional purposes than do the EPA and the Corps under the Clean Water Act. Swamp Buster involves eliminating federal farm program benefits if you farm what is deemed to be a wetland. And the definition of a wetland there is totally different. So farmers and ranchers still have to worry about that. And that has absolutely nothing to do with what we're talking about here on these EPA amendments. So farmers have to remember they can get caught 2 different ways with respect to wetlands.
Talking more about navigable water, then that really takes out ditches and drainage systems for producers.
As long as there is no continuous surface connection to a navigable water of the United States, then yes, it would be removed from jurisdiction now under the Sackett opinion.
Those EPA amendments on August 29th, kind of what were a few of those key amendments?
Well, they did several things, and of course the 2 big ones that we mentioned is that they removed the significant nexus test. That's a big one. And they said that we're limiting jurisdiction over wetlands to just those that are relatively permanent and have a continuous surface connection to navigable waterways. So those are the 2 main points. So I take from that wetlands which would share a surface water connection with the water of the United States and no longer have that connection due to man-made barriers such as levees and dikes or sand dunes, they're no longer included in the definition of a WOTUS. And so that's what I was talking about a moment ago, where you can't connect the dots. And so if you've got man-made barriers, the significant nexus test cannot be used to connect that wet area to a jurisdictional water of the United States. The other thing I would point out, Shelby, is that these amendments became effective immediately as soon as they were issued on August 29, and they were finalized without the agencies issuing a draft for public comment under the Administrative Procedures Act. The agencies were relying on a good cause exception that is contained in the Administrative Procedures Act, claiming that the rule was sufficiently urgent that they had to get this out. And of course, they were saying that the Supreme Court put them in this position. But I had said all along that they were kind of foolish for putting the rule out in advance of the Supreme Court's opinion, because the Supreme Court could invalidate it. And indeed, they did in large part.
And are there still some unanswered questions, however, within all the definitions and all of this work that has been done around it?
Yeah, I think some of the nuts and bolts issues are still not defined. I would focus on what is a ditch, what are they going to take to be their position from a regulatory standpoint with respect to ditches, and even other farm features that are filled with water only sometimes, such as these ephemeral streams. Are they changing their longstanding definition of those to conform to the Sackett opinion, or are we going to have more litigation on these particular issues? And I still kind of feel that this is not going to be over in the courts. We're probably going to have more litigation with respect to even these amendments.
And Roger, where does Kansas stand on this?
Well, that's a good question, because prior to the amendments, and actually prior to the U.S. Supreme Court opinion, the new rule by the current administration had been enjoined by federal courts in 27 states. So that rule wasn't currently enforced in 27 states. The government could not enforce it, and Kansas is one of those states. And that litigation is still out there, even after the Sackett opinion and after this amendment came down. So I really don't know what's going to happen with that litigation on the rule itself. Those are outstanding cases, and they're paused, and I think their future is uncertain at this point in time.
Roger, then is it fair to say that things aren't settled by any means of this, and probably we'll still have more to talk about in the future?
Oh, I think it'll give us fodder for further discussion in the future. I don't think this is settled, but at least we have a more clear U.S. Supreme Court opinion than we've ever had. And again, we had unanimity on the fact that the significant nexus test was the incorrect test, and that is a step forward.
And talking about changes with farming and things related to agriculture, the I-9 form, which is something important to producers and to farm operators, recently kind of got a little bit of a makeover.
It did, and the I-9 is the form that verifies the identity and the employment authorization of farm employees, and it protects the employer from penalties associated with hiring improper people, such as illegal aliens. So this is what protects the employer, it protects the employee, and it's a pretty important form, and it has to be completed within a short time frame after a worker is hired. And so, and again, this is one area where there's no exemption for ag employment based on size or family ownership of the farm. Everybody is subject to the requirement to fill out a Form I-9. And you're right, a new form came out on August 1. It is mandatory starting November 1. And I would encourage people to take a look at my blog article on this. I do provide the link to the form so they can actually go precisely to the government's source where they produce this form and take a look at that, print that out if they're hiring ag workers, and use that new form starting November 1.
And on that new form, have some of those questions been kind of condensed or reworded to hopefully make things a bit smoother?
They did. In some instances, it clarifies, for example, the differences between non-citizen national and non-citizen authorized to work, and it can be filled out on tablets and mobile devices. And there's a checkbox that's been added for employers to indicate when they have remotely examined the Form I-9 documents. And there have been certain other revisions that have been made, too, and as well as the instructions to the form. Those have been updated. So people need to take a look at that. If you're hiring ag workers, that's a pretty important document.
And just reminding people that that document does have a time limit of when it needs to be filled out once people are hired.
Right. They've got 3 days from the time of hire to complete the form, and then employers have to hang on to the form and make it available for inspection for a certain period of time, too.
And Roger, for people who would like to go read your article, where can they do that?
You can find it on my blog, and from the homepage of my website, you can access my blog, and that's washburnlaw.edu/WALTR. The blog articles are also posted on Ag Manager through the Department of Ag Econ at K-State.
Roger, I appreciate you taking the time to join us today and once again giving us an update on some things related to agricultural law.
Thank you, Shelby.
That was K-State and Washburn Law Professor Roger McEowen discussing recent WOTUS changes and the revised I-9 form. I will link the articles discussing both of these topics in today's show notes, which you can find on agtoday.net. You can find more of Roger's work by also going to washburnlaw.edu/WALTR, or his blog posts are often also posted on Ag Manager's website at agmanager.info. I will link all of these resources in today's show notes, which, as always, you can find on agtoday.net.